Let's hear from the Democratic Alliance spokesperson, Karabo Gagau, on why it is that the party disagrees with the expropriation bill and what steps they will be taking from this. Karabo, perhaps to start out here, and this is the fundamental point, what is the disagreement of the DA with the Expropriation Act?
Hello, Oliver, and hello to your viewers. Fundamentally, there are two reasons why we are against the bill. One, we do not believe that the bill meets constitutional muster, and two, procedurally, the process that was followed in Parliament to pass the bill and the Act was flawed. One, on the constitutionality of it, you have two clauses within the Act that are in direct contradiction of each other. The one section of it as to how the process of restitution will follow speaks to there being a court process that will follow after there being negotiations that are had between two parties affected, either one who's supposed to bring back the land or one that is supposed to take it. After those negotiations have already taken place, and only after then the onus on the person who is not satisfied with the negotiation lies on the person. The onus lies on that person to approach the courts to do so. So that's the one possibility that is written in the Act. The other one says that before the conversation even happens on the negotiation, there's going to be a set out amount altogether. It could be nil, it could be 100,000 rand for argument's sake. And even if then whoever is as unhappy finds themselves in a position that they're in disagreement or with the conclusion, then the onus lies on them to go to the court. What the other consideration with it, the Act says that, but you should have courts and an arbitration process that fairly has a negotiating a mandate there for everybody to make sure that there are outcomes that are right. So those two points within the Act are in clear contradiction of each other. And this is something that we do not want, because ultimately what we want as the Democratic Alliance is to ensure that we give more muscle to Section 25 of the Constitution to ensure that the state is able to deal with redress, restitution and land reform accordingly. You can't, as a president, unilaterally take a decision to pass an act that it has those fundamental contradictions within itself together without consideration of legal advice that has been given to the president of this contradiction. And so, because already the Minister of Public Works had already given the president an indication, a legal advice that says that this process needs to go back to Parliament so that we don't have to so that we can clear this contradiction, we have a problem there. The second problem that we have as far as the procedural master of the problem is concerned is you'd recall that in the previous administration, the NCOP process for passing the bill was also flawed. The principle of negotiating mandates says and dictates, Oliver, that for each province to come into the NCOP and have voting power, they need to have undergone the process of sittings within the respective 9 legislatures that exist to have those legislatures pass and give a mandate to the NCOP to consider. We know that the Eastern Cape, we know that Gauteng and Limpopo did not do this, which meant that their voting mandates within the NCOP were flawed. Therefore, the tallying of the total 7 votes in favor of the bill were not correct. So these are but a few issues that we have with the procedure that Parliament sent. And essentially, what is also important for South Africans to understand
just to interject there, we don't have much time. I do get the sense of what your objection is. Just a side comment. Not sure that the contradiction that you speak of is there, but the procedural fairness is one that is of serious concern, as courts have already and in previous cases opined on procedural soundness of lawmaking. Importantly, John Steenhuisen, the leader of the Democratic Alliance, says that two things have happened. Clause 19 of the 19.3 in particular, the statement of intent of the Government of National Unity has been invoked, and therefore it has to be taken to a vote. And should there be no sufficient consensus, that the dispute resolution mechanisms of Clause 20 ought to kick in. And that is the Clearing House Committee chaired by Deputy President Paul Mashatile. In the very same address, John Steenhuisen accuses the Clearing House Committee of being a mechanism that is abused because it has no terms of references. If the DA has no confidence in Clearing House mechanism, why bother with it to begin with?
Look, this is why it's important to have noted that the leader has said that this is a resetting opportunity for the GNU to get a clearinghouse committee that actually works, the mechanism that works, so that disputes of this nature don't have to find themselves in either court or here in the media, but they can be resolved internally. Particularly because when we do that right from the onset, we save time and we're also able to apply ourselves more energetically towards addressing the issues that South Africans are concerned about. We're able to spend more time on growing the economy, on creating jobs, and making sure that we alleviate poverty altogether. And that's why, in invoking this clause, John Steenhuisen has made it clear to the president that he also needs to come to terms with the fact that he's not alone. The Democratic Alliance didn't enter into the GNU to copy-paste and rubber stamp ANC policies. The president cannot go and sign laws without consultation with GNU partners, which in this case, GNU partners, the minister that is responsible for the department that is affected by this law, as well as the leader of his biggest partner within the GNU, had to find out via Twitter and social media that there's an act that is being signed in the law. This is problematic. It does not work, and it does not serve the interests of South Africans. But because the Democratic Alliance is committed to ensuring that South Africans have a sober government of the day that will deliver to them, to make sure that they have basic services, that they have dignity, and a government that cares for them, that we're setting the button and making a call to ensure that we finally have a house that has things in order.
Yeah, other than the three technicalities and the technical minutiae that you have outlined that the Democratic Alliance takes issue with, it seems to me from the reading of the statement by the Democratic Alliance leader John Steenhuisen that the DA is also opposed to the substance of expropriation altogether as a principle, saying as much as this will chase investors away. There are many other countries in the world that have similar policy provisions. The USA has something of the same, as well as the UK. Why is it that in this instance, it would chase investors away?
So this is the misconception here. So what chases investors away is unconstitutional laws that do not meet legal master, that do not lead constitutional master. We're not saying the act of expropriation itself, as is the case, as is something that is empowered by Section 25 of the Constitution, is problematic. A constitution that we as the Democratic Alliance also support and want to uphold, and have always been pro acts of restitution, redress, and land reform. That is the misconception here. What must be clear that investors want to have a government that passes laws that are sober, that pass legal master and constitutional master. No investor wants to invest in a country that is run like a banana republic. And that's what we need to be able to fix here, particularly because we have a reputable a legal advisor that has been able to give facts to why exactly
so has the president, right? The president has also claimed to have had sound legal advice from senior counsel across the country, and in various instances, very respectable senior counsel in the country. So it's yet to be determined whether or not the bill does not meet the constitutional master. The DA hasn't yet won the argument on that. Just 10 seconds, wrap it up.
So here's the thing. If the president's legal advice was sober, then we would have had a better country for the last 30 years. The ANC has failed under his leadership, so his legal advice is not something that we can trust as a country, and that's why we're invoking Section 19 of the Statement of Intent, so that we can gather around under the same table, find each other in the best interest of all South Africans affected.
Thank you so much for your time. Really do appreciate it. That's the Democratic Alliance spokesperson.